Now, the reason people get patents is because they provide protection that you don't get with other kinds of IP rights. Okay, I use this example. This is Mark O'Meara, who is a golf player, and he had some success at the expense of Tiger Woods several years ago. And this is actually an interesting case in IP law. Now, what had happened, why he was so successful, and subsequently why Tiger Woods was so successful in the about a decade and a half ago, really came down to the construction of the golf ball. So it's actually golf ball technology. And what happened was, until about the turn of the millennium, golf balls were essentially soft core. Then a company called Bridgestone created a solid core ball. So in other words, this, instead of being filled with a liquid or being hollow, was a solid object. And when Tiger Woods switched to a solid core ball, his game improved remarkably. And then what had happened was another company called Titleist decided, oh, that's a good idea, we'll copy the solid core ball. And they did. And they ended up having a fight with Bridgestone. Essentially, Bridgestone had in its arsenal a patent. Titleist had a trademark. And not surprisingly, Bridgestone won. And it's because in this case, the patent trumped the trademark. Now, different IP rights essentially can protect different things. And in some cases, in this case, the patent trumped the trademark. Now, I take it some of you have a prior IP experience, so this won't be of any surprise to you. But part of the reason patents are so sought after is because you cannot protect some of the things. Sorry, patents protect things you can't protect with other IPs. You will notice inventions, applications for new discoveries, improvements really can be protected under patents the way you can't necessarily protect them under other IP rights. Patents protect inventions. Unlike copyright, which protects expressions and, not ideas, they can protect the underlying idea. Patents, as I noted before, offer monopoly-like rights. Now, I talked about novelty. Novelty means, in patent law, not in the state of the art. It doesn't mean it is original, which would be the dictionary definition. Okay, it doesn't mean it's brand new, it's never been seen before. You can take an existing product, find a new way to use it, and it will be novel. An example would be if you get, let's say, Tylenol for a headache. That is not novel. But if you got Tylenol and use it to make, I don't know, pizza, that would be novel. So there is no requirement for originality, and patents can be extremely valuable. In the valuation class, I actually talk about the value of the Lipitor patent. That was worth a couple of hundreds of millions of dollars, if not billions of dollars. And in some cases, particularly in the pharmaceutical industry, patents are possibly the best form of protection because the patent protects the underlying formula. So if you copy, let's say, a medicine or a drug, okay, you are infringing the patent. You don't get that kind of protection with copyright. You don't get that kind of protection with trademark, and you certainly don't get anything like that with a trade secret. But you can protect IP, certain kinds of IP, drugs actually are possibly the best, patents are the best form of protection, and that's why there are all these extensions available to the pharmaceutical industry, and that's why these extensions are so highly sought after, because patents are so valuable to pharmaceutical companies.